Morning. My name is Priya Bhatia, and I'm faculty in the Professional Development and Competence Department at the Law Society of Upper Canada. Welcome to today's presentation, Capacity, Consent, and Substitute Decisions, an Essential Update. I'd like to welcome our participants in today's Toronto Lecture Hall and also those of you participating at our remote locations via BarX. I'd like to make a few brief announcements before we begin today's program. First of all, please turn off your cell phones or mute them if you haven't already done so. I'm pleased to inform you that today's program does qualify you for the legal aid panel. If you have any more information, any more questions about being a part of the panel, you should contact Legal Aid Ontario. We do value your feedback on our programming, so we encourage you to fill out your gray evaluation forms that are contained in your materials. In Toronto, you can submit those in the box outside the lecture hall, and for those of you at our remote locations, please feel free to fax or mail to the contact information provided. In order to increase access to CLE across Ontario, the Law Society will be recording today's presentation and will be distributing it in video format. Such recordings may capture images or voices of those of you in the Toronto Lecture Hall today. Regarding questions for today's program, we have a few ways for you to ask questions. You can ask questions at the end of the sections or panels. We're going to endeavor to save some time there, and that's for those of you in the Toronto Lecture Hall. Or there is a question sheet. It's a blank sheet that just has lines on it. It's in your materials. If you have a question you'd like specifically answered, you can jot that down, and there's a box on either side at the front of the lecture hall, and we'll endeavor to answer those questions. For those of you at our BarX locations, we're actually taking faxes of questions today. Fax your questions to 416-947-3370 throughout today's program, and we'll endeavor to have those answered for you. Finally, I'd like to take this opportunity to thank our program chair, Arthur Fish, and our many presenters who've devoted a great deal of time and effort into today's program. Without further ado, I'm going to introduce Arthur. Some of you know him. Arthur Fish is a partner in the Toronto firm of Borden Ladner Gervais LLP, where he's the regional manager of the Estates and Trust practice and a member of the firm's health law group. His practice is restricted to estates and trusts and healthcare related matters with an emphasis on issues related to aging, disability, and mental incapacity. In 1994, Arthur received his doctorate in law from the University of Toronto. He is the former chair of the Ontario Mental Health Foundation. Arthur is also a member of the Ontario's Consent and Capacity Board and a lecturer in the Department of Psychiatry and a member of the Joint Centre for Bioethics at the University of Toronto. Finally, Arthur is the co-author of a book on mental competency assessment called When the Mind Fails. It is my great pleasure to turn the floor over to Arthur Fish.
Thank you, Priya, and good morning, everyone. Every time I step into this room, I think of the Bar Admission course. And I know that you're all thinking of the Bar Admission course, and it's kind of reassuring to start the day knowing that you've got nowhere to go but up. I'd like to thank Kathy Castaldo, Priya Bhatia, and the staff of the Law Society for making the planning of today's event such a pleasure. And I'd like to thank all of the speakers, each of whom has volunteered considerable amounts of time to structure today's program and ensure that the various pieces fit together. This is the second of these programs that we've offered. We offered the first one because there had at that time been enormous changes across the board in the applicable law. And the profession was slowly finding its way into those new and very complicated pieces of legislation. This time around, there are changes that we're going to discuss, but not the kind of titanic changes that led to the initial program. Rather, we're now in a period of evolution as the practicing profession begins to work out what the various pieces of law that we have to deal with day to day mean for us and for our clients and their families. And the inspiration for offering the panel again, or the objective of offering the panel again, grew out of a widespread recognition that as the population ages, this area of law will touch every legal practitioner, every family, every commercial enterprise in the country, and in many respects, the quality of life for hundreds of thousands, if not millions of Canadians will turn in large part on how well we, the members of the legal profession, do in coming to grips with the dilemmas that arise from aging, disability, and mental disorder. And it bodes well for the future that so many of you have been willing to give up your time and come and learn and share, both here in Toronto and sitting at your desks via the BarX program. Let me repeat, for those of you who may have missed it on the first go-round, that the BarX participants can fax questions to 416-947-3370. And let me reiterate what Priya said. You've got the gray response sheets, and I personally would be very grateful if you take the time to fill them out. I can tell you that in planning this program, we looked backwards to the comments that we'd received in connection with the first one. I hope there'll be a third iteration, and I can assure you that if there is, any comments you offer on today will be taken very seriously. With respect to questions, we'll do our best to fit them in, but I've said to all the panelists, I'd rather have you give a relaxed and thorough presentation than rush through for the purpose of offering a minute or two of questions. But virtually all of our participants have agreed to remain for some period of time following their talks, and they've all asked you to please not be shy when it comes to approaching them and putting your questions to them privately. We've also got these question forms, as Priya has mentioned, in 2 boxes up at the front, and if people bring questions forward, I, as your chair, will do my best to pose them on your behalf. What I'd like to do now is move immediately into our first panel, which has been designed to ensure that, I know from looking around me that we've got a fair smattering of old hands in the room, but I can see that we've also got people who are here for the first time, and the purpose of this panel is to give all of us a refresher on the main pieces of legislation that govern the civil side of this topic, and to ensure that those of you who are coming fresh to the topic have an opportunity to get up to speed along with the old hands. So the first presentation that we'll hear will be from Diana Schell, sitting to your right, my left. Diana is counsel to the Ministry of the Attorney General, Legal Services Branch. She holds a diploma in nursing, in addition to a law degree, called to the bar in 1989, and she's widely known for her practice in the areas of mental health disorder, consent and hospital law, with an emphasis on litigation. Sitting next to Diana is Nimali Gamage, who practices with the firm Jan Goddard and Associate since October 2002, a Toronto law firm that the practice of which is restricted primarily to the fields of adult guardianship, estates and trusts, and emphasizes the service of older clients and their families. Nimali is a graduate of the University of Ottawa Faculty of Law. And finally, my partner, sitting immediately behind me where you can't see her, Cindy Clarke, who is an associate with the Toronto office of Borden Ladner Gervais. Cindy graduated from Western Law School in 1997, where she was awarded the Torque and Mains Cohen and Arbus Award for excellent scholastic achievement and outstanding contribution to the law school. No surprise to those of us familiar with her effervescent personality. With that, I'm going to turn the podium over to Diana. Thank you, ladies and gentlemen.
Thank you, Arthur. I had forgotten about that screen over there. What an appalling thing to look over your shoulder and see as you're up here speaking, but I'll try and get over it. As Arthur has indicated, we were aware in planning this conference that a fair number of people participating would not have a significant background in practicing in the area of mental health or consent law. So I've been asked to provide some high-level context statements with respect to mental health legislation generally, and also with respect to the Mental Health Act. Other people later in the day can do more of the heavy lifting. This will be quite a high-level discussion, just to provide a bit of context. I personally think that the history of law in this area is fascinating, and maybe other people don't, but you're going to hear a bit about it anyway. Now, let me see. Okay. If you go to Google or any other easily accessible search site, you will find lots of information about the history of legislation in this area. In the common law world, it goes back at least to the 12th century. The legislation you see referred to here from the 13th century, I won't even try to pronounce it because I always butcher Latin, but in any case, there has been legislation around for centuries, primarily dealing with the property of people who we would now call mentally ill or developmentally handicapped. And I think it's an interesting feature of this law that even then there was the law distinguished between people who had developmental problems and those who had mental illnesses, and treated them differently in the sense that the mentally ill were presumed to be able to recover and may assert a right to their property at a later date, whereas the property of people with developmental handicaps just as cheated to the Crown or reverted to the Crown automatically. And as I've already mentioned, the focus of this law was on the property of the individual and protecting that property for the individual should he regain capacity or his sanity, and for the individual's dependents. But even back, way back then, if you look at some of this information, you'll see that the law also distinguished between people for criminal purposes, and that there are examples of the courts excusing people from criminal responsibility for very serious offenses committed when the person was not of sound mind. The other interesting thing I think about this is that the use of institutions to care for the mentally ill dates back at least to the 13th century. The Priory of St. Mary of Bethlehem in London was one of the first institutions that was used for the care of the mentally ill. And you may have heard the term bedlam. Well, that's the Priory, and that's where that term comes from. And just to show you that the more things change, the more they stay the same, one of the first, I don't know if I'd call it a commission of investigation, but a body appointed to investigate conditions for the mentally ill was in the 14th century, and that was a review of the conditions in Bedlam, which were considered to be deplorable, even by the standards of the day. What we've seen, I think, since then is a long continuation of this kind of law. The law from the 13th century was continued more or less in the same form, or at least in many respects in the same form, right up to the 19th century. And there was really very little dispute about whether or not there should be specific laws that dealt with the mentally ill in different ways than the law would deal with other people. The dispute about how much the state should intervene in the lives of the mentally ill is really something that has arisen more in the latter part of the 20th century. And at that point, you see books like Thomas Zaza's The Myth of Mental Illness that really question whether mental illness is some kind of social construct, the result of child rearing, or whatever. Now, for myself, I will say that I don't think that that kind of dialogue has been particularly helpful, that mental illness is reported historically, cross-culturally, in virtually every culture, and more recent research would tend to confirm that it has a neurophysiological basis, at least for the major mental disorders. And I'll apologize if for those who don't agree with that, but I think that is the case. In any case, every province and territory in Canada has mental health legislation. That legislation focuses on hospitalization, consent to treatment, and property matters. Up until 1995, Ontario's Mental Health Act dealt with all three things for people who were admitted to psychiatric facilities. So again, that would be hospitalization, treatment of mental illness or psychiatric treatment, and property. Now, hospitalization may be voluntary, it may be involuntary, or it may be consented to by a substitute decision maker. And in Ontario, the term that's used to describe somebody who's admitted with the consent of another person is an informal patient. I really don't know where that terminology comes from. For a long time, mental health legislation talked about formal and informal patients, and it's not a term that, is self-explanatory. The term formal patient, I believe, referred to an involuntary patient, and that has been disappeared from the Mental Health Act for, 20 years now at least? The legal interest in this area under mental health legislation, at least the hospitalization part of mental health legislation, is focused on the state's power to detain people involuntarily. The term that is typically used for that is civil commitment. And I've made a note here just for those of you who are interested in division of powers. The authority to legislate in this area is provincial. Okay, now there was an initiative in the 1970s, I believe it was, to have uniform mental health legislation throughout the country so that each province or territory would have fundamentally the same legislation, and it would facilitate transfers between jurisdictions and do other nice things. But that has never panned out, so that each jurisdiction in Canada has its own piece of legislation or a number of pieces of legislation in this area. But if you examine this legislation, generally speaking, there are some common features that you can find throughout. And the first point I bring to your attention is that the power to commit lies with the medical profession rather than the courts. So this is quite different from the US, where civil commitment is something that the judiciary are responsible for. Now, most legislation in this area allows for some sort of initial short-term confinement for the purpose of assessment. You may have heard of something called a Form 1, Physician's Application for Psychiatric Assessment under the Mental Health Act. That is a form that can be completed by any licensed physician in the province of Ontario if the statutory criteria are met, and that includes an examination by the physician within the past 7 days. That form authorizes the detention of a person in a psychiatric facility for up to 72 hours for the purpose of an assessment. And after that, the person can be detained as an involuntary patient, again, if the statutory criteria are met. And another feature of this legislation is that involuntary status can be renewed. The Certificate of Involuntary Admission in Ontario is a Form 3. Certificates of renewal are Form 4, and they allow for periods of detention. The first one would be for a month, the second one for 2 months, and the third one for 3 months, and any subsequent renewals are for 3 months. The Form 3 Certificate of Involuntary Admission allows for detention of up to 2 weeks. Whoa, I don't know if I think I've gone one too far. Well, I'm not going to go anywhere with this because I can't get it to move in either direction. I want to tell you that a typical feature of this legislation is that a person must be detained in a designated facility. And in Ontario, the Mental Health Act only applies to those facilities that are designated by the Minister of Health and Long-Term Care. That's one. Thank you ever so much. And I've later in these slides, I've provided you with the link to the ministry's website in case you're interested in seeing which facilities in Ontario have been designated as psychiatric facilities. And I'm going to tell you a little more later on in this presentation about how to navigate your way through those schedules and understand how they operate. Legislation throughout Canada allows for a person's apprehension pursuant to a physician's application. And when you look at the various criteria for admission as an involuntary patient, you will see that while mental disorder is a requirement, it's not the only requirement. There are different kinds of standards used in legislation. You can find dangerousness standards. that is that the person's a risk to self or others, or standards that really focus on the person's best interest. The person needs to be in hospital because the person requires protection. In Ontario, up until 2000, we had exclusively a dangerousness standard. Well, actually, I'm probably wrong about that. We had a standard that included dangerousness and also the ability to detain people who were at risk of suffering imminent and serious physical impairment. In 2000, December 1st, 2000, amendments were made to expand the criteria for civil commitment to include individuals who had a history or who have a history of mental disorder and who are likely to suffer substantial mental or physical deterioration as a result of decompensating while they're out in the community. I'm going over these statutory criteria in a highly general way. Of course, you're going to need to refer to the legislation to see all the details of the criteria. And if you're interested, though, the criteria are in Section 20 of the Mental Health Act. About half the provinces use a dangerousness standard and the other half use a best interest standard. And for all of these typical features in mental health legislation, they are found in our Mental Health Act. The Act has 5 parts. It's set up in the usual way that legislation is set up. It has definitions at the beginning. It doesn't have a purpose statement. It says various things like who it applies to. Again, it only applies to psychiatric facilities. Now, I just note for you that the Mental Health Act was always legislation that was based on an institutional model of care, so that it started off with the premise that it applied to designated psychiatric facilities and all of the services that or other issues that were covered by the Act really related directly to psychiatric facilities. Community treatment orders may exist in the community, which probably doesn't come as a big surprise. And it's not necessarily required that the person be associated with a psychiatric facility at the time the community treatment order is issued or renewed. So in some ways, this is not a very good fit with the Mental Health Act, but nevertheless, that's where you find the community treatment order provisions. And there is, of course, a presentation later today about those things. Now, Arthur has given me the 5-minute hook, so I'm going to start breezing through some of this stuff. I've provided you with a list of the things that the Mental Health Act covers. On this slide, you might just note that there are specific provisions with respect to children 12 to 15. And those provisions, I'm not sure how much they're relied upon anymore, since most services for children and youth are provided either by the Ministry of Community and Social Services or the Ministry of Youth and Children's Services. Nevertheless, there are provisions in the Act that authorize the admission of 12 to 15-year-olds with the consent of a substitute decision maker. And people in that age group have rights to challenge that admission. People under 12 do not. And I'll also just note for you as well that the involuntary admission rules apply regardless of age. So it is possible for a very young person to be civilly committed in this province. Again, I don't know how common that is. All right, let's just move on. Let me go back to that. Ministerial orders for transfer in and out of Ontario. I'll just tell you about that one because it's one of those obscure things that sometimes comes up and only people like me actually know how this works. Periodically, the ministry will get a call about somebody who's being expelled from a foreign jurisdiction. This is a not uncommon scenario, or perhaps is coming to us from another province and having absconded from a psychiatric facility in Alberta. There is authority in the Mental Health Act for the minister or somebody delegated by the minister to complete a Form 13 and that authorizes the person's admission to hospital. And you have to sort of search your way through the legislation, but I'll just tell you, a Form 13 operates exactly the same way as a Form 1 and provides the same authority for a person's admission to a psychiatric facility and detention there for an assessment of up to 72 hours. As far as ministerial orders for transfer out of Ontario are concerned, those are virtually never issued. That's a scheme that was developed based on this idea that there would be uniform mental health legislation throughout the country so that these kinds of exchanges can occur. But I've been with the ministry for 15 years and I'm not aware of an order taking somebody out of the province ever being issued. Just to take you back to that last, whoops, no. There's a psychosurgery reference there just to tell you that the legislation does not authorize psychosurgery, and substitute decision makers, and again you're going to be hearing more about that from somebody else, but substitute decision makers cannot consent to psychosurgery. Now, the estates provision of the Act used to apply to inpatients and outpatients of psychiatric facilities. Now it's the case that the property part of the Mental Health Act requires an assessment of a patient's capacity to manage his or her property, but it doesn't apply to anybody else. It only applies to patients in psychiatric facilities. We have virtually no agreements about veterans, and then there's the usual catch bag of things at the end of the Act. Now, Arthur asked me to speak a little bit about the jurisprudential statements about the purpose of the legislation, and those are provided in a couple of cases towards the end of the slides. In particular, I draw your attention to the Day case and the Bricka case. They're both old cases, but they still say what they say, and occasionally it's relied upon in factums filed for the purposes of appeal under this legislation. Now, in case you're wondering, that was the 1-minute hook I got there, so just taking you to the related legislation. The Healthcare Consent Act's been around since 1996. It replaced the Consent to Treatment Act, which was only in force for a year in 1995. The Substitute Decisions Act replaces many of the property rules that were in the Mental Health Act, and you're going to be hearing presentations on both of these matters. Okay, so you have the links. There's the general link to the Ministry of Health website, which is just a mother lode of information and you know, some promotional stuff as well. And the list of designated psychiatric facilities is found at that site. The list of designated psychiatric facilities might be a little hard to navigate your way through. It's based on regulatory requirements for 5 essential services that have to be provided. Section 4 of Regulation 741 says that a psych facility has to provide inpatient, outpatient, day care, emergency, and consultative and educational services to local agencies. But you can be exempted from any one of those requirements, and the schedules are set up on the basis of those exemptions. The important thing to know is that only a Schedule I psychiatric facility can detain a person involuntarily. If you are interested in issues related to the Ontario Review Board and the Forensic Mental Health System, this most recent review and various proposals for making the system better is posted on the Ministry's website. Rights and responsibilities, this was most recently updated in 2000. It's something that's been around forever, but the last time it was updated was in 2000, and I'll just flag for you that it hasn't been updated to include the amendments in the Personal Health Information Protection Act that comes into force next Monday, and will be undoubtedly a source of more work for all of us. Okay. Thank you very much.
Hi, I'm Cindy Clarke, and I get the pleasure of seeking some assistance on how to get my slide presentation up. While that's happening, I'm speaking today about the Healthcare Consent Act. I must admit it feels somewhat unusual to be standing up in this position and recognizing that there are some real experts in the room who I work with, and we engage in lots of debates about the meanings of these provisions often. So you may hear different interpretations from people along the way. But again, my goal is just to give you an overview of the Healthcare Consent Act and to give you a sense of what's in it and where you can go within the Act to find and solve the problems that you're faced with. My plan today, well, this got some fancy things on there, is to review the main principles of the Act. I've divided it into the key components from my perspective. I'll give you a few examples of leading decisions. I've given you just a few fact scenarios to give you a flavor of the kinds of things that can come up in this area of the law, and then some lessons learned. And those are general lessons that have come through collective experience around dealing with consent and capacity issues and dealing with the Consent and Capacity Board itself. So first of all, the basic principles of the Act. I want to first go through all the things that it covers. This is an Act that's designed really to be used by people on the front lines. I think you might dispute whether it is as user-friendly as the drafters hoped it would be, but this is something that, for example, we speak at hospitals about frequently and tell nurses and nurses' aides and physiotherapists and occupational therapists, physicians, everyone in the healthcare community should be familiar with this legislation and should have a general working understanding of what its components are and how to apply it. So that's sort of the target market for the legislation, and it's really designed for the front lines. So it defines the meaning of consent. It outlines the activities that require consent. It includes a presumption, very important, and I'm going to be speaking about this a fair bit, that all patients, all persons are capable of giving consent, and it outlines how to determine if a patient is capable. So you have a presumption of capacity, and then it tells you what to do if you're questioning that presumption. It outlines the hierarchy of substitute decision making and works in concert with the Substitute Decisions Act that you're going to be hearing about shortly. It outlines the principles for making a decision on someone else's behalf, and it outlines the process by which a patient can challenge a finding that he or she has been found incapable of making the decision at hand. So just that overview itself gives you a flavor that this is quite expansive legislation. It's divided into an initial part with obviously the important definitions and the important key principles about capacity, but then it is divided into 3 sections, and the good news is that each of the sections is set up in the same way, and each of the sections has pretty similar principles within it. So once you get a handle on one, then you can pretty much get the rest of it underway. So the first and one of the most important parts of the legislation is consent. This is our codification of the common law around what does consent mean. And obviously consent means that it can either be express or implied. It doesn't have language in the Act about the nature or the form that the consent must be in, but the consent must relate to the treatment or service. So it has to be specific to whatever it is you're proposing. It has to be informed, and lots of debate about what informed means. It means some explanation of the material benefits and the material risks. How much of a risk do you have to describe to the patient? Well, that's when you get into the gray zone, but you definitely need to get into a description of the risks and benefits of the proposed treatment or service. It has to be given voluntarily, and it must not be obtained by fraud or misrepresentation. So before you do much of anything, and we're going to describe what that is, you need to make sure you understand what consent is and you understand the components of getting consent. When is consent needed? Consent is needed when you want to initiate a treatment, and we'll define treatment shortly, but it's a very broad definition, and I think there's only a few things. The Act has the definition within it, and it has the exceptions listed under Section 2, and the exceptions really relate to assessing someone's capacity, getting a history from a person, communicating a diagnosis. It's extremely limited. So most activity that involves interacting with a patient at some level would be defined as treatment. Admission to a care facility, you need consent for this, and this is defined as being the long-term care charitable institution, sort of anything that we generically call a retirement home, nursing home, long-term care facility. That requires consent. The area of the legislation that is missing a little bit is the issue of chronic care facilities, so persons who are not eligible for long-term care but they need to be placed somewhere. I think it's clear and implied that you need consent for that as well, but it doesn't technically fall under this category. And then the provision of a personal assistance service also requires consent. In my experience, this is not an issue that's challenged nearly as frequently as the treatment or the admission components of the Act. This is really your activities of daily living, and as you'll hear, consent is something that can change and is relative to the decision at hand. And I think it's because, as well, capacity can change, and people tend not to get as concerned about the consent that's required in order to give someone a bath or help them change their clothes, and mostly because it's often implied, right? So if the person cooperates with you and goes along, then it's not so much an issue. And it just frankly doesn't get the attention that the other two do. So when consent is needed, and again, treatment has a really broad definition, so it's important for, if you're ever advising clients who are in any way could be giving something that could be called treatment. So anything done for therapeutic, preventative, palliative, diagnostic, cosmetic, or other health-related purpose. And very importantly, it includes a course of treatment, plan of treatment, or community treatment plan. And what that's getting at is, and I think the best example is often now well established in long-term care facilities. So if you have an elderly relative, you may know about this. But the goal would be to sit down at the beginning of the year and to review the plan. So what is the health status of the patient right now, or the individual in the home? And what are the things that you might reasonably anticipate would come up for that individual? And what's the plan that everyone agrees upon? And the beauty of this is that you can give consent to the plan, and the plan has a lifespan of whatever it is that you've agreed to, and then you don't need to get individual consent every time. So the plan might include that there's going to be physiotherapy once a week, that the individual is going to participate in recreational activities, that the nurse is going to come in once a week to check on the individual. The plan can cover quite a broad range of things, and then that's one vehicle of providing a comprehensive consent. So then we get into the presumption of capacity, because of course you can't give consent for any of these things unless you're capable of giving consent. That's why it gets a little bit complicated, but the presumption in the Act is that every person is capable of giving consent, and as we just heard, that means every single person. The presumption, there's no age limit in the Act, there's no definition of when you are or are not capable, other than the test that's in the Act, which is a subjective assessment of the person. So presumption, very important, is everyone is capable. That's further important because if you are working with or representing someone who's made a finding of incapacity, or a healthcare provider who wants to go against that presumption, of course the onus is on you. The onus is on the person who is claiming the incapacity to prove the incapacity. The individual gets the benefit of the presumption. So how do you determine if someone's capable? You want to get consent, you're allowed to presume they're capable. I think the general rule of thumb is, unless you have reason to believe otherwise, you can follow the presumption. But the test you need to turn your mind to, or your clients need to consider, is whether the person is able to understand information that's relevant to making the decision in question, and able to appreciate the reasonably foreseeable consequences of a decision or lack of decision. And this test is, I think, one of the most considered and debated issues at most consent and capacity board hearings, and it's also received lots of judicial consideration. I think it's more often that individuals pass the first component of the test. That is, they have the mental capacity to understand the information. If you ask an individual about the medication that's being proposed, or what it means, or what it's called, or what it might do, what it is, people can have an understanding of the basic information about the proposed treatment. Sometimes, not always, but it's more the second part where we find that people are more apt to raise questions about their capacity, because you need to be able to show you can do a cost-benefit analysis. You need to be able to demonstrate, not only do you understand what's being proposed for you, but you understand how it relates to you and what it means to you. I understand what this decision means to me. I understand that when I say I want to go home, this is a good example. If you're talking to someone who's being found incapable of going to a nursing home or long-term care facility, they will often say, I want to go home. And they understand the information. When you say, I'm talking to you about your ability to make a decision about where you live, they'll say, I don't want to go to a nursing home. I know what that is and I don't want to go there. So they pass test number 1. They know what a nursing home is. The more difficult challenge is, does the person understand the consequences of their decision? Does the person understand that if they go to the nursing home, yes, it will limit their freedom, but it will also provide safety and food and a nurse to watch over them and someone to look after them. And if they go home, they face a lot of risks. If the person has dementia and they've been prone to leave the stove on, or they fall and there's no one there to come and see them, if the person can articulate that and say, I know the risks of going home, I know that I might fall out of bed and I'm willing to take on that risk, I appreciate that it might be safer for me to be somewhere else, but this is my choice, then the person is capable. If they're not able to really appreciate the differences and not able to make an informed decision, then they don't have capacity to make the decision at hand. Section 10 is very important. No treatment without consent. And of course, you can't obtain no treatment and none of the other things that I've already listed, but you can't obtain the consent until you're satisfied the person's capable, or you get consent from the substitute decision maker. Capacity can fluctuate, so it fluctuates relative to the decision at hand. You can be capable of making some decisions and not others. And it fluctuates with time. There may be times if you come into the emergency department unconscious, you're incapable, but having received the appropriate treatment, you may the next day have recovered and you may then be capable. So it's a very fluid thing. It doesn't say stay stuck for any length of time. And again, no age determines when one is capable. Hierarchy of decision making is consistent with the Substitute Decisions Act, and it's all set out in Section 20. And the principles of decision making, when you're making a decision on someone else's behalf, you look to prior wishes. And those, I think the key there is the prior wish actually applicable to the circumstances at hand? And if there is no prior wish, then you need to decide in accordance with the patient's best interests. And those are actually set out in the legislation for you. And then, very importantly, and how we get into lots of interesting debates about all of these issues, is that a patient or individual has the right to challenge a finding that he or she has been made incapable. So the Healthcare Consent Act sets out the process that's to be followed, and essentially what you do is apply to the Consent and Capacity Board, and there's different rules about the formation of the panel whom you'll appear before, but in essence, within a very short period of time, there should be a hearing. It's usually at the place where the individual is located, be that retirement home or hospital or the board office if you need a neutral location. And at that point, you have a hearing to consider the issues that usually start with, is the person capable of making the decision? The job, I guess, of the Consent and Capacity Board is to decide if they uphold the finding of the person who's made the decision of incapacity. They have other jobs as well, and you'll see, I'm really short on time here, but when you read the Act, you'll find out that it talks about being able to challenge not only the finding of incapacity, but you can challenge whether a substitute is acting in the best interests of the patient. A substitute can apply to the board for direction on how to make a particular decision. But important to remember that unless you're in the emergency treatment or crisis admission category, which is really quite limited, no treatment is to be provided and no admission to a care facility can be arranged until you sort out the issue of consent and until you get the capacity determined by the board, if you have knowledge that there is going to be an application. So obviously you have to respect the patient's rights. And I've got in my slides the facts and the key lessons that have flowed from all of this, and I'm sorry that I don't have a bit more time to go through all of that, but I think coming back to the history of the Mental Health Act, and when you're dealing with this issue, I guess what I think is important to remember, and it's something that I remind my clients frequently is that you're really dealing with very, very serious issues of individuals' autonomy, of our whole sort of free and democratic society, and your right to make decisions on your own. And that can be challenging for people that are family members and healthcare providers that are on the front lines who are doing what they think is best for the patient. And I think that most people would agree. I think even my colleagues who we debate about capacity issues, I think they agree that most people are motivated by trying to do the best thing for the person. Key lesson is that this legislation is not directed at doing what's in the best interest of the patient. The legislation is directed at very appropriately sorting out if individuals are able to make that decision for themselves. So you need to move away from considering and being swayed by, I'm doing the right thing and that's all that matters, and you really need to focus on, can this person make the decision for themselves? Do they have the capacity to do that? And if they do, they can make crazy decisions. We have that right in our society to make decisions that others disagree with and that may not make a lot of sense. But the balance is to protect those who are vulnerable and those who are not really mentally capable of making an informed decision. Then there's the process for allowing someone else to come in and make that decision on their behalf. Because of the significance of all of this and the important underlying principles, there's strict rules around process, and those need to be followed carefully. If you don't follow the process, number one, someone will be after you and they'll make sure that you do follow it. But even more importantly, the process is there to protect the vulnerable patient. So if you're dealing with clients on the healthcare side, encourage them to be patient, encourage them to understand the underlying purpose of the legislation and not to get caught up in the busyness of doing their job and forgetting that just ticking off a box, it's not such a big deal. Well, it can be a big deal because process matters, and it matters to the board, and often decisions can get overturned and can get set aside if the process hasn't been followed. So I think the whole gist of the lessons learned from this legislation is that everyone is focused on protecting the vulnerable patient, and everyone needs to make sure that they're applying the legislation in the way it's meant to be applied, and that if it's challenged, you are in a position to bring forward convincing and cogent evidence to support your view. So I'll leave it at that and leave you to review the lessons learned, and we may have a chance after the panel to talk about it further. Thank you.
Good morning. I don't have a slide presentation for everyone to follow along with while I'm talking, so you're just going to have to hang on my every word. I have, however, provided a paper which is in the materials, and it summarizes the Substitute Decisions Act and provides case briefs of some of the recent cases pertaining to this law. But I'm not going to go through all of the cases. As Diana mentioned in the beginning, the purpose of this panel's discussions is basically to give you a primer of the legislation. So with no further ado, in December 1992, the Ontario Legislature unanimously passed the Substitute Decisions Act 1992, which I'll refer to as the SDA from now on. And it came into force in April 1995 with amendments coming into force in March 1986. And to state its purpose broadly, which I like to call the cocktail party definition, when people say, what area of law do you practice in? Basically, it's the law regarding the capacity to make decisions about property or personal care and what happens in the event that a person can no longer make those decisions. But more specifically, the SDA has several purposes. First, it provides definitions of incapacity that are specific to the type of act to be done. And this is a very important aspect of the legislation that I find I pull out in my practice very often, especially when dealing with counsel who are representing other parties in the situation who may not have knowledge of these different definitions. For example, the SDA provides different definitions for the capacity to manage property versus the capacity to make one's personal care decisions, which is different from the capacity to grant or revoke a power of attorney. And so in essence, it takes away this concept that someone can be globally incapable of doing everything, which is a very useful thing to know in your practice if your client is perhaps incapable to do one thing, but the issues at stake are pertaining to other things. And the definitions of the different capacities are not based on medical diagnoses, which you'll find some people may try to argue as well. They'll have a medical diagnosis of some medical condition and use that to make the conclusion that the person is incapable of doing something. But actually, the definitions of incapacity are based on a person's ability to understand certain information specific to the act to be done, or the person's ability to appreciate the reasonably foreseeable consequences of making that decision or a lack of decision. So it's crucial that when practicing in this area, you and any experts that you're going to hire understand these different definitions. The second purpose of the SDA is that it, in essence, created this concept of the power of attorney for personal care, which allows people more control over their affairs in the event that they become incapable of making their own decisions. Third, it provides a legislative scheme for the appointment of guardians without having to resort to the Mental Health Act or the courts, and this is referred to as statutory guardianship. Fourth, it defines the duties and powers of guardians and attorneys, thereby providing safeguards and accountability of substitute decision makers. And fifth, it provides procedures that are to be followed in court applications for guardianship, in addition to the rules of civil procedure. So, although the SDA is organized in terms of parts that are titled property, the person, and then guardianship applications, I'm actually going to discuss the SDA more in terms of, first of all, how a substitute decision maker comes to get their authority to act, and then secondly, the duties and the roles of those substitute decision makers. So, first of all, there are three ways in which a person can get authority to make someone else's decisions. There's a power of attorney, there's statutory guardianship, and then there's court-appointed guardianship. So I'll deal with each of these in turn. First of all, this SDA sets out rules regarding the granting of a continuing power of attorney for property, which is a power of attorney for property that survives the subsequent incapacity of the grantor and takes effect immediately when it's signed, unless the document itself provides otherwise. Now, if the document states that it does not take effect until the grantor becomes incapable, but the document itself doesn't provide a method for determining incapacity, Section 9 of the SDA provides such a method. And the SDA also sets out rules for resignation of an attorney, the termination of continuing power of attorney for property. Now, regarding personal care, the SDA created powers of attorney for personal care. This document can cover decisions related to 6 areas: healthcare, nutrition, hygiene, shelter, clothing, and safety. And it's important to note that unlike most powers of attorney, which take effect immediately unless they say otherwise, powers of attorney for personal care do not take effect until the grantor is incapable of doing the specific act. So if a power of attorney for personal care authorizes the attorney to make decisions to which the Healthcare Consent Act applies, for example, and the Healthcare Consent Act authorizes the attorney to make the decision, the attorney can then make the decision. And I'm not going to go into further detail about the Healthcare Consent Act because we've already heard about that this morning. But I would like to say that the Healthcare Consent Act does not cover all healthcare decisions, and it doesn't cover the other 5 areas of personal care. So for these decisions, the SDA provides that the attorney may make a specific decision if he or she has reasonable grounds to believe that the grantor is incapable of making that specific decision. So what you'll find in a lot of cases is that someone will be made the attorney for personal care of someone else, and they'll be told that, and they'll think that that means they have the authority to make any decisions with regards to that person's personal care whenever they want or when the person's capacity starts to diminish. And that is a huge misconception out there, not just among non-lawyers, but also among lawyers. So it's important to know this distinction, that the person has to be specifically incapable to do the specific act before the attorney has the authority to act. And now, this authority is subject to any conditions that are contained in the document requiring the incapacity to be confirmed by some sort of formal process. However, most powers of attorney do not have a condition like this in them. So practically speaking, what happens is the person who's been appointed the attorney will just start to act on the basis of informal evidence, meaning their reasonable belief that the person is incapable. So that's where the line is, well, not actually a line at all, is quite gray. And if a client comes before you who says that, who thinks that they are not incapable, and the appointed attorney has just started making decisions on the basis of informal evidence, one idea may be to examine if the person is capable at that time of revoking the power of attorney document. So next I'd like to discuss statutory guardianship. And this is different from court-appointed guardianship, which I'll discuss later. Rather, statutory guardianship occurs by operation of law, where there is no valid power of attorney for property in place, and a person is found incapable of managing property pursuant to a specific assessment, which is an assessment done under Section 16 of the SDA. The public guardian and trustee automatically becomes the person's guardian. And then a family member or a trust company can then apply directly to the public guardian and trustee to replace her as the guardian, and that's pursuant to Section 17 of the SDA. There's a couple things I'd like to note here about statutory guardianship. A Section 16 assessment specifically relates to statutory guardianship. So if you're seeking court-appointed guardianship rather than statutory, a different type of assessment is used, and that's pursuant to Section 22 of the SDA. And the reason I'm bringing this up is because I know that it has happened in many cases where this distinction between the different types of assessment was not made, and instructions were given to a capacity assessor that an assessment was needed, and if the assessor doesn't know which type of assessment you need, they may follow the guidelines for a Section 22 assessment, which doesn't serve the purpose if you're trying to get statutory guardianship. Or on the other hand, the capacity assessor may do a Section 16 assessment, which if your client is a family member who is wanting to do a court application for guardianship, and you instruct an assessor to do a Section 16 assessment, and all of a sudden the PGT becomes the automatic guardian, your client is not going to be very happy because that, even though the family member can then apply to replace the PGT, that really wasn't the plan that you set out in the beginning. The other thing to note about statutory guardianship is that there are different procedures for appointing statutory guardians of property for people who are patients in psychiatric facilities, which Cynthia has mentioned. The procedure for assessment of patients in psychiatric facilities is covered by Section 54 of the Mental Health Act. When a certificate of incapacity is granted pursuant to the Mental Health Act, Section 15 of the SDA provides that the public guardian and trustee automatically becomes the person's guardian of property, similar to when a Section 16 assessment is done. So these guardianships are also subject to all of the provisions in the SDA. For example, the PGT can also, in this situation, be replaced by a family member under Section 17 of the SDA. And one final point to note about statutory guardianship is that it's not available for a guardian of the person. It only applies to guardians of property. So next I'd like to discuss court-appointed guardianship, which is the third way that someone can get authority to make someone else's decisions. The court may, on a person's application, appoint a guardian of property or a guardian of personal care for someone who has been found by the court to be incapable of managing property and or incapable with respect to making decisions in one or some or all of the 6 areas of personal care. The court is prohibited, specifically in the SDA, from appointing a guardian if the need for decisions can be made by an alternate course of action that does not require a finding of incapacity and is less restrictive of the person's decision-making rights. And the important thing to note about that point is that when a client comes to you and says they want to apply to be a guardian of whoever, of a family member, it's important to note, to inform them that the court process for guardianship can be quite expensive, and that the court is not even allowed to appoint a guardian if there are other less intrusive means of the person managing their property or their personal care, which in many cases there are. If the person's, for example, if the person's income is from one source and can be directly deposited into a bank account, and there are very minimal sort of standard payments that can be directly made from the account, there are many ways in which financial decisions can be arranged without the person actually having to have a substitute decision maker in place. So if that is the case, then it's important for you to advise your client of that from the beginning before they incur all the expenses of a court guardianship application, only to get to the court and be told, you know, we're not making a finding of incapacity and impinging on this person's liberty when their affairs can be arranged in a less intrusive manner. So this brings me to the point that in a court application for guardianship, one of the things the court has to do is make a finding of incapacity. And so counsel representing an applicant for guardianship must put forward of the person's incapacity. And this can be difficult in cases where the applicant does not have access to formal evidence of incapacity, such as a capacity assessment. It's especially problematic in these cases where the applicant does not have access to the incapable person. For example, access is barred by other family members, but the applicant knows that something fishy is going on. Thank you. So in these cases, lawyers representing the applicant can either go forward to court on the basis of the anecdotal evidence that the client's giving them, that the applicant is giving them, and in some cases, it will be cogent enough evidence for the court to make a finding of incapacity. In other cases, it may be enough evidence to warrant the court ordering that a formal capacity assessment be performed. Or what an applicant can do if they don't have access to the person and they don't quite have enough evidence of incapacity is if they have enough evidence that something fishy is going on, they may apply to the PGT to request that the PGT, the public guardian and trustee, conduct an investigation. And perhaps the results of that investigation will provide more formal evidence that can be put before the court. The SDA also sets out rules regarding who can apply to be a person's guardian, how to vary a guardianship order, the posting of security by a guardian, conditions of a guardianship. I'm not going to sort of go through all of those because you can read those in the Act. I just want to highlight a couple other points. As I mentioned before, you should note that the SDA provides a partial procedural code for these court applications for guardianship, which is important to note because there are some requirements regarding service and documents that must be filed with the court and served on parties, in addition to the rules that are set out in the Rules of Civil Procedure. Next, I'd like to discuss the duties and powers of guardians and attorneys. A guardian or attorney for property has the power to do anything on the incapable person's behalf in respect of property that the person could do if capable, except make a will. For example, the guardian or attorney can open and close bank accounts, redirect income, deal with investments, sell the incapable person's home. As for guardians and attorneys for personal care, the range of powers will depend on what functions the person is incapable of performing. So if the person is incapable with respect to all 6 areas of personal care, then the guardian or attorney will, of course, have a broad range of powers. So this power to manage someone else's property or personal care decisions is an extremely serious obligation, and the SDA requires that the guardian or attorney perform his or her duties diligently, with honesty and integrity and in good faith for the incapable person's benefit. It specifically states that the guardian of property is a fiduciary, and the courts have ruled in the landmark case of Banton versus Banton that the attorney for property is too. Section 32 of the SDA provides a list of the duties of a guardian of property. And I'm not going to go into more detail about them. I've provided a bulletin that the public guardian and trustee puts out, and it's on their website as one of the appendices to my paper, which is a really useful bulletin to give to people who are applying even before they apply to be guardians, so they know what they're getting into, as well as to give it to guardians themselves, so they know exactly what their duties are. Instead of running through these duties, I just want to, because I don't have much time left, I want to quickly just read you a passage of, from the Banton decision written by Justice Cullity, which I didn't include in my paper, so, but it's a really important passage with respect to the SDA and the duties of attorneys and guardians. He wrote, an attorney for a donor who has mental capacity to deal with property is merely an agent, and notwithstanding the fact that the power may be conferred in general terms, the attorney's primary responsibility in such a case is to carry out the instructions of the donor as principal. As an agent, such an attorney owes fiduciary duties to the donor, but these pale in comparison with those of an attorney holding a continuing power of attorney when the donor has lost capacity to manage property. In such a case, the attorney does not receive instructions from the donor, except to the extent that they are written into the instrument conferring the power. The attorney must make decisions on behalf of the donor, and pursuant to sections 32 and 38 of the Substitute Decisions Act, he or she is a fiduciary whose powers and duties shall be exercised and performed diligently with honesty and integrity and in good faith for the incapable person's benefit. The status of such an attorney is much closer to that of a trustee than an agent of the donor. This has been the case since the Powers of Attorney Act was amended in 1979 to permit the creation of such powers. It is now made explicit in the provisions of the Substitute Decisions Act I have mentioned, and others including those dealing with the standard of care, the ability to seek the directions of the court's power to remove the attorney, and the right to compensation, and the rules relating to the passing of accounts. So as for guardians and attorneys for personal care, the Substitute Decisions Act requires that they too perform their duties and powers with diligence and good faith, that they shall explain to the incapable person his or her duties and powers, encourage the involvement of the person's family and friends, and foster the incapable person's independence. The SDA also states that the substitute decision maker shall choose the least intrusive course of action that is available and appropriate, and maintain records of the decisions being made. Section 66 of the SDA sets out the guiding principles for a decision making by a guardian of the person when the Health Care Consent Act does not apply. As mentioned before, these decisions can include some healthcare decisions and decisions with respect to nutrition, shelter, clothing, hygiene, or safety. And I just want to conclude with saying that the SDA not only provides us with an opportunity to assist our clients in arranging their financial or personal affairs, but it also gives us an opportunity or a basis for which to advise the substitute decision makers themselves, which I find a really useful thing about the SDA, is having this opportunity to sit down with guardians or attorneys before they actually start to act and tell them what their duties are. Thank you very much.
Thank you. Please join me. Let's have a round of applause for all three of our panelists who've discharged a fairly tough mandate with aplomb. It's not easy to skip through hundreds of pages of legislation, and you've really done an admirable and helpful job of it, and I thank you all. If the next panelists would please, the next five panelists would please come forward towards the end of the coffee break. We're going to break now for 15 minutes. Coffee break here in Toronto, whatever you bar people want to get up to, you're permitted to, I suppose. And thank you very much, ladies and gentlemen. Great. How are you doing?